Hello, everyone. Thank you so much for being here. While you get settled in, I'm just going to take a few minutes to go over our disclaimer. And before I introduce our guest and get started. So thank you so much for joining us. Advice Chaser, the host of this webinar, is not a registered investment advisor. Advice Chaser cannot and does not give financial advice. This webinar is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this presentation, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, principles, or jokes expressed by presenters are their own and however true, interesting, or funny are not endorsed by Advice Chaser. Please do not act on the information in this recording or during this webinar without consulting a qualified financial professional. We're so excited to have you here today. And our webinar topic today is particularly important to many people, and we're so glad you're here. Just a second, and I will introduce you to our speaker today. Let me just pull that up. We did have a little bit of, oops, we don't need that. We did have a little bit of technical snafus earlier, and we've got those all ironed out, but I didn't quite have something on my screen I need to have. Here we go. Just a reminder that attendees are muted, but we encourage you to ask questions using the chat box. The presenter will answer those questions during or after the webinar as appropriate. And if you ask a question in the chat box, go ahead and leave your number. And if we don't have a chance to get to your question, we'll make sure someone reaches out to you after today's event. We want this presentation to be as educational as possible, so please don't hesitate to ask for clarification or expansion of the material. Today's presenter is Joseph P. Okras, who specializes in retirement and long-term care planning for current retirees, those retiring in 10 years, engineers, professionals, college employees, and small business owners. Joe also does financial planning work for individuals who are going through divorce who have been recently divorced or widowed. Joe is an investment advisor representative. He maintains licensing in life insurance, annuities, long-term care insurance, and disability insurance, as well as investments. He is also a National Social Security Advisor certificate holder. Joe has been a licensed attorney in Michigan since 1994. He was the managing partner of a law firm in Southeastern Michigan prior to working as a financial advisor. Joe resides in Ann Arbor with his 3 children. And Joe, I'll go ahead and turn the time over to you.
Okay.
And okay. I can't wait to hear about what you have to share with us today.
Okay. Hello, everybody. Thank you for joining us. Today's, like Marche said, today's webinar is Women in Divorce, which I have a long line of experience with. Our Marche, introduced me, and I was managing partner of a law firm that represented specifically women going through divorce and family law matters for 17 years. So I have great experience in that regard. 2009, I jumped over to retirement planning, and my dad's been in the business since 1963. So I joined my dad 12 years ago now in the retirement planning business. He has an office in Clarkston. My office is in Ann Arbor. And our specialty, or truly a niche market specialty, is women going through divorce, or widowed women, or single women. But it's really a specific category in a niche market. I had a client the other day said, well, I didn't even know there was such a thing. Well, there is, and as we go through the slides, I can get more into detail about it. But one of the things is just having that compassion, and I guess grace, mercy, compassion to work with women going through a difficult time period, and then also helping women in the retirement planning needs. And like I said, as we go through the slides, it will kind of play itself out and why we chose this specialty, which we really enjoy working in this niche market.
And I know that, I'm just going to break in here, Joe, that I
Okay.
know that when we planned this webinar, we talked about how so much of divorce planning does have to do with retirement planning. So you're doubly experienced in those fields.
Yes, yeah, that's correct, Marche. And I think that's important for everybody to know as we go through the slides, what's important for people going through these type of situations to work with somebody you're comfortable with. And we'll touch on that in the slides. But like Marche said, also, we also welcome, we want this to be interactive. So everybody on the call, don't hesitate. If you have questions, get them to Marche and we'll be happy to answer them for you. So now we'll go ahead and get started. Know your current projected expenses. Now, what we're talking about in that situation, going through a divorce is obviously very difficult. One thing that people have to do or realize in a divorce type of situation is you had one income and one budget, funding typically one household. Now, everything is changing as this process changes, and so you have to adapt to the situation. So your pre-divorce budget may be two incomes coming in or one income coming in for two cars, two sets of various insurances, but one household. And so it's important that you realize when you get to the point of your post-divorce situation, life is going to change. And our job as a retirement advisor and then your divorce attorney who you're working with during the process is to try to make that as seamless as possible, as comfortable as possible, and to not rock your world too much, even though there are going to be some significant changes there. Like I would give an example. I'm working with a woman now going through a divorce. They have pretty big assets, and it's a one income marriage from the husband. She was an engineer and retired 20 some years ago as an agreement of the marriage. Unfortunately, things have happened in the marriage, not her doing, that are leading to this divorce. So I'm kind of working with her, and I'm lightly working with her because they live in a very expensive home. And she's like, I really want to stay in that home. And I'm trying to tell her that one income from your husband, I don't want you're in your 60s. I don't want you to have to necessarily go back to work. So our goal is that her divorce attorney is able to accumulate enough assets, but I'm kind of trying to gently break to her. I don't know if you're going to be able to keep up $4,000 or $5,000 a month mortgage payments when we're going to be alimony and a chunk of money coming over from the retirement plans, which we'll discuss in a second. But so it's important for you to sit down when you're going through a divorce or hitting that point, or even in a widowed situation as well, just knowing that budget and knowing your financial situation. And one way to do that, like we said, is you want to work with a financial advisor, retirement planning advisor. We highly recommend you work with somebody, like I said, that is in this niche market, that has the skills to work in these situations, because it is really different. And also that understands the process of going through a divorce and what you just went through and how hard that was on you. And I'm a fellow divorced person myself, so I know what you're going through and I know how hard it is. So having this confident, positive advisor to work with that understands not only what you're going through during the divorce situation or widowed situation, as well as how to work with you under those circumstances and plan for your future, so that we keep you as seamless as possible and so we can still enjoy life and do things the way that you were doing in the past. Because one thing we always look at is, if you have children, I want you to focus on your children. We want you to focus on your emotional health, even your physical health, and stay healthy, and let that advisor or professional take care of the rest for you. So that's why it's really important that you build a bond with your advisor and have a nice, close relationship with an advisor. And one specialty, like I said, one of our kind of characteristics of our specialty is we work with women going through these situations, and we're trying to be calm and patient and understanding, as well as educate. We're really big into the education. I have a law degree and MBA. I'm focused on education. I don't want people, one thing I always tell clients when they come in, especially in these type of situations, is the last thing I want you to do is jump in your car and you're leaving our office and you say, I have 10 more questions, just like I did when I left my doctor's appointment. So we try to really educate, take our time, spend as much time as necessary to make our clients feel comfortable, let them understand that they can rely and count on us while they take care of themselves and their children.
And I'm just going to break in here. That's probably
Okay.
just good. That's probably just good advice for anyone who is looking for advisors in this area, and
Right.
to have someone who's compassionate and will listen to them and answer their questions. So I'll go ahead and move on to the next slide.
Okay, so the next slide we're talking about is divided assets and debts. The bullet points. Okay. How are assets and debts divided? So when we're talking about a divorce case, each case is, I said this to Marche before, and she liked it, but I always say each divorce case or each situation is like a snowflake. It's its own case. So one thing I tell people is when you're going through the process and going through a divorce, focus on being around positive people for one thing. You're going to get advice from everybody, and everybody's an armchair quarterback in divorce. Everybody's an armchair quarterback in retirement planning. So stick with the positive people, stick with your professionals, and try to, and a lot of times it's family, it's very good friends, but I try to tell people to try not to dig too deep into people kind of that are telling you, well, this is what happened in my case, so it's going to happen in yours. So every case is 100% different. So what happens in a divorce case is the court will file the paper, or, the plaintiff will file the paperwork. The defendant is the person responding. Right off the bat, typically in a case, any competent divorce attorney is going to file what they call ex parte motions at the beginning of a divorce. So there's going to be a motion that is telling both parties neither party can dispose of, hide, transfer assets, as well. All bills will continue to be paid as they were being paid during the divorce. So that's the idea, is everything stays status quo during the divorce proceedings. And as you get into the divorce case itself, the attorneys will then end up negotiating. They'll have a discovery period where you'll be asking either depositions or questions or asking for documents, trying to determine what assets are out there, what debts are out there. And from there, the two attorneys will work together with the client to try to determine what is our division of assets and our division of debts going to be. So you want to look at the case when you look at it and say, in that situation, without getting into detail, the situation I was discovering is we're trying to work out and say, okay, what's the best move? Is it our best move to stay in the big home but potentially bury yourself in debt? Is it our best situation maybe in reality, and maybe it's a fresh change of pace? So like, hey, let's put this home up for sale. Let's divide assets. Maybe going back to the last slide, let's work on your budget. Let's keep things, and I know you don't want to, but unfortunately, a divorce does bring on change, and it's not always for the best, but we're trying to make it the best. So in that situation, we want to look at it and say, okay, if a husband has a business, then maybe we want to pay out from the business, and maybe we want some form of the assets from the marital home, or maybe we want greater form of the retirement assets, less debt, because he, in that situation, may have greater ability to continue to take on the marital debt while I take assets because I'm starting fresh. So every case is its different situation. So it's important to work with somebody that can kind of help you. And what I mean by that is I'll work with, a lot of times in the case, talking to the divorce attorney, we'll go back and forth on, I don't overstep my bounds. The divorce attorney is doing their thing and they're excellent at it. But okay, maybe our client in this situation, let's try to fight maybe for a greater share of that 401k and let the income earner have the business and take the debt, or maybe retain the marital home. And the way it works out in a divorce itself is you do the discovery period. Obviously, the goal of everyone is to have the case settle as smoothly as possible. Unfortunately, sometimes they don't. Most divorces do not go to trial, but some do, and usually they're hotly contested cases that go to trial, either with child matters or with asset matters. Usually high asset type of cases are the ones that may go to trial, but in reality, most of them settle. Sometimes the two parties can agree upon it, which is nice and the most efficient way to do it. If that doesn't work, then the courts will typically appoint, or the parties will pick a mediator to try to settle the case, or an arbitrator. If that still doesn't work, then it's the trial route. And trial judges, divorce judges hate doing trials. They're just very hard. They're time consuming. They put the whole court's docket behind. So they're really trying to force the settlement. But unfortunately, it takes two people to settle. And I always say one difficult person makes a divorce difficult. So you want to still defend yourself, protect yourself, but just be aware that the court, each case is going to take its own path, and each divorce takes its own path.
And I wanted to remind our viewers that Joe recorded another webinar with us about the steps of divorce, and that is available on our website if you'd like to watch that, as well as kind of supplemental to this webinar. I did have a question come in. Can you talk a little bit about how the marital home is handled in a divorce, especially when both of the spouses are on the title or on the mortgage?
Okay. So in general, in Michigan, I'll hit the mortgage part, but I'll talk the title first. The title doesn't necessarily matter. It's a marital asset. If you're married, that date going forward, the assets are accumulated in a marriage. So if one spouse came into the marriage with the home, for instance, the other spouse, you get married, say on January 1st, 1999. Going forward, divorce attorneys will go back and determine the value of the home on the date of marriage and say, okay, that person, whoever owned the home, is entitled to the value up to that point. Everything there going forward is marital assets. So say on that January 1st, 1999, the home was worth $200,000. Now it's worth $500,000. Technically, even though you weren't maybe on the title, you're entitled to 50% of that $300,000 increase in the home. Now, mortgages make it really difficult in a case because, especially in a market where homes aren't selling, it's really hard to do, because what happens is the mortgage company will come in and say, we could care less what that divorce judgment says. You're on the hook for it. You're going to pay for it. Now, you can say something in the divorce judgment can say otherwise, or the divorce judgments can say non-mortgage holder is responsible for paying the mortgage until the house sells. However, if they don't, the mortgage company comes back and says, we could care less. We want our money, and we're going after the person who obtains the mortgage. So ultimately, what you want to try to do in a situation, but it's always not possible, if the home, one person is retaining the home, say that was agreed upon, the person will retain the home, we would request as a divorce attorney, then, as say we were the one not retaining the home, we want you to get refi and get this home in your own name and pay off whatever we're going to pay off to each other, split the assets, and you have a new refi. But say a person lost their job, or say the person that's going to retain the home is the one that doesn't have a nice income and they can't get a mortgage. So there's no set answer to it, but the ultimate goal is this: whoever's going to, if somebody's going to retain the home, we prefer that person refi and get it in their own name, but sometimes it doesn't work as cleanly as that, and you end up bringing people back to court. I'd say 30–40% of divorces end up having post-judgment motions where it brings people back to court.
Thank you. I know that's an issue that's come up, and
it comes up a lot, and it's a tough issue. Sometimes there's no clean, good answer to it, especially if it's like a slow real estate market. Now, it's a little easier now, at least in Michigan, because houses are selling fast because there's limited supply, so it doesn't come up much. When you go through a dead market like in 2008, that was a big problem in divorces because nobody could sell their home. And people were not paying their portion of the mortgage, or they weren't paying it. It was hurting the other person's credit rating. Like I said, the mortgage company and outside third party, that includes also credit card companies, they could care less what a judgment says. They do not need to adhere to it. That
So you're
agreement.
still on the hook, even if the divorce decree says they owe half or
Yeah, they have to
whatever.
pick up the debt. That's what leads to, that's the kind of thing that leads to a lot of divorce bankruptcies. That's a big
Mhm.
bankruptcy market, is divorce bankruptcies, especially in tough economies and recessions.
Can you talk a little bit about, now I know that you said in Michigan about the asset division based on the date of the marriage. I know in other states, there's the 50-50 rule. I know, and that's a minority of states. Can you talk a little bit about just, I know we're talking specifically about Michigan, but maybe talk like how important, what that kind of looks like in those other
Yeah,
areas.
well, Michigan's technically a 50-50 state to start with, just in general. However, as a good divorce attorney, spouse is messing around, we're gonna force the issue, just being honest. We're gonna say, okay, we're gonna take a judgment, we're gonna do a deposition of you and your new girlfriend or boyfriend. We're going to put pressure on you. We're gonna delay this thing as long as possible to try to get a 60-40 split or 70-30 split. So that's where good divorce attorneys come in, where they know how to play the game, because it is a game. Divorces are a game. So in cases like those type of situations, a lot of times we have to tell our client, who is the person causing it, I know you want this over with, but hang on, because it's going to put a lot of pressure on the other party to settle. They want to settle. And if we delay this thing and push it out, that's why we're shooting for 60-40 or a greater share of assets. Now, every state is different, so it's hard for me to necessarily know how every state works. I would say most states are in the 50-50 type of range now in the United States, is that I'm aware of. There's some states may look at it and do fault, and fault is where it comes into play. Now, Michigan's technically still a no fault state, meaning anybody can file. It's still 50-50, and negotiating and tactics is what makes it something other than a 50-50. Some states might be more straight down the line. It's 50-50. We don't care what happened. And some states are like that with kids too. I thought Wisconsin may be like that. I have a friend who went through a divorce in Wisconsin, and it sounded like they were almost split right down the middle, 50-50. And this is the way it is with children as well as assets, which I look at that. I'm like, what's the point of even having a divorce attorney in that, in some of those states? Because that's the leverage of like a Michigan type of state, where it starts out as a 50-50, but then negotiating tactics, skills,
Mhm.
understanding psychology and how the whole game works is what leads to better quality divorce attorneys and getting you a greater share by guilting, forcing, pressuring, those type of things. But yeah, it's hard to say across the board, every state,
Every state's going to be a
but
little bit
a little bit
different.
different. Yeah, and you're a divorce attorney in that state, will know. But I would think that most states are probably following somewhat of a no fault now, starting at a 50-50 and go from there.
All right, so here's our next topic.
Okay, so spousal support, that's our next topic, and which most people are aware of it. Spousal support means alimony. Most people are familiar with the term alimony. Most movies, TV shows still call it alimony. Michigan is definitely called spousal support. I'm not sure if other states have changed, but I'm not sure why they even changed. If it was softer to say spousal support, but that's what it's pretty much called now, is spousal support. So the way that the courts look at spousal support, and spousal support can go either way. A man can be collecting, a woman can be collecting. It really is a negotiating topic. Now, there will be spousal support guidelines, just like child support guidelines, where the attorneys will have software and they'll plug in the specific variables of the case and shoot it out. Child support stays more on point with it. Spousal support is just a guide, because what we're looking at in a spousal support, obviously, if you're married 1 year and you're 24 and 23 years old, there's not going to be any spousal support or alimony. If you are a long-term marriage and there's a serious discrepancy in income, then you are going to have a spousal support situation. The longer the marriage, the greater discrepancy in income, the greater and longer term spousal support will be. If you are in a situation, and a lot of our clients we represent all different age clients, but a lot of them are say 50 and up, and a lot of them have been like 20 plus year marriages. When you start getting longer term 20, 25, 30 year marriages, one person, say, is making 200,000 a year, the other person either retired to stay home with the children or just got back into the workforce, there's going to be typically a 10-year plus spousal support. Some of them are lifetime spousal supports in those long-term big discrepancy cases. If you're married 10 years and there is somewhat of a discrepancy there, there might be spousal support, but you might be looking at, say, 2 to 5 year spousal support. It's negotiated by the parties. The arbitrators or mediators, if it gets to that point, will also give a recommendation on it. But like I said, they start with a foundation of the software, and then they go from the software point to the attorneys. Then we'll look at that just as a foundation, and then they'll negotiate from there. But it's another one of those snowflake things in a divorce where it's wide open, and then it's another area. That's a big area where you want an effective, skillful divorce attorney to understand how it works, because there's huge variables and variations in spousal support.
All right, this is the big one.
Okay, child support. Now, child support is the same way, like I said. So there is software that all divorce attorneys will have software that, and what they'll be plugging in is time with the children, overnights with the children. It's all based on the negotiations of, first you're looking at, okay, who's getting the kids, who's going to have the time with the kids, who's going to have the overnights, and then you're getting the variable of that. And then they're also plugging in your incomes, and then it's spitting out a number. Now, like I said, this software, the attorneys stay much closer to this number than they do to spousal support number. Spousal support is really just a guide or a foundation. Child support stays pretty close. If they're battling on it, if parties can agree on it, it works. If not, friend of the court will get involved and try to settle that matter. Friend of the court really gets involved when you have children in a case, and the parenting time, custodies, and child support matters.
That's a new term to me. What does friend of the court mean?
Okay, so friend of the court, and I believe all states have a friend of the court. Michigan definitely is a friend of the court. So what happens is when you file your divorce complaint, we'll just give an example here. We're in Washtenaw County and we're in Metro Detroit area. So we're in bigger counties where there will be multiple divorce judges or family law judges. So say you're in a court system that has 3 family law judges. When you file your complaint, you're automatically assigned to a family law judge. That family law judge has their own lineage. Almost if you look at the hierarchy of president, vice president, directors in a corporation setting, that'd be the judge, and then there'll be the family law referee will be underneath it, and then there'll be their support specialist under that. So each judge has their own friend of the court referee. So the friend of the court referee oversees. So it's almost like the divorce judge is delegating that portion of your case to the friend of the court. And friend of the court is the one that is going to try to assist you in settling the child support, the parenting time, and custody of a divorce case. Child support, like I said, it's really based on, they're looking at overnights, they're looking at the parenting time schedule, as well as the income. They're plugging in the factors, and then that will determine child support. If you have multiple children, a lot of times in your divorce, if say you have 3 children, it might say when 3 children you're paying child support for 3 children, it's $2,000. 2 children, $1,500 a month. 1 child, $1,000 a month. So you're going to typically have a fall off as the children fall off. And that's what we mean by multiple children on there. Child support typically stops, and don't hold me to exact terms because, like I said, I haven't practiced since 2009, but I stay on top of it. But as graduate from high school and turn 18 is typically when your child support shuts off. So for instance, if you have one child left, child graduates on June 1st, 2021, and turned 18 on May 1st, 2021. As soon as that graduation is up, whoever's paying child support, that last child support payment would be May of 2021. So that's kind of how the shutoff determines what child support until they're all off the board, and then child support is completed.
can you talk a little bit about what if you have a child who is disabled or has special health care needs? What kind of situation it, it happens there?
Yeah, one thing that's gonna come into play in those situations is going through the Social Security Administration, because you might be getting SSI or various disability type of benefits coming from the Social Security Administration for your child, and that may go on and depending on the disability, well into their adult years and adult time frame. As far as a divorce case goes, it's something that could be negotiated. If you have a household or one person's mainly taking care of the child, the other person has large income, maybe that's something that's negotiated into that you will continue to pay excess money beyond the typical child support ages and situations. So that's, I mean, it's a tough one in the sense that each situation is going to be totally different, but most likely you're going to some form of government aid to begin with, and depending on the assets of the party, and then in that case, you sure hope both people are reasonable and understanding in that. And then if I'm making 300,000 a year and my soon-to-be ex-wife is the one that's really the caregiver of our child with, say, epilepsy, Downs, or whatever they might have, you sure hope that other one is caring and thoughtful and is going to say, you know what, I'm going to step in and make sure our son or daughter is okay for the rest of life, even though we might have our differences. But like I said, you're getting some typically government aid at that point, and it's a negotiated matter also.
And there are some other points here as far as questions go. Can things like childcare, college expenses, and other things that like even car insurance, can those be also put in the divorce decree, or do you recommend that they
Well,
just have a on
chi-
paper
yeah,
agreement?
childcare is definitely one that's a factor that plays into it, along with the child support and the child care. So that's one, because that's usually when they're still within that child support age range, so that fits into there for sure. And that will be something that's negotiated and determined at that point. Now, there are situations, and you do see battles with this. Okay, he or she is paying 2,000 a month in child support, but we have our child in daycare. They're still not school age. Say they're in daycare, like pre-kinder care type of situation. It's very costly. It's eating up 2,000 of my, it's eating up 50% of the money I'm getting child support. A lot of those things are going to be negotiated, and that's where friend of the court may be stepping in to try to get you some resolution or something that makes both parties survive. But typically, a lot of those expenses will be negotiated in there. You might get child support plus 50/50 on child care type of situations. So that's definitely, child care is definitely playing into it, because you're still under that graduate from high school, turn 18. Post child support ages, as far as paying for college, insurances after that point, those are really typically how the parties agree to do it afterwards. You can put it in a judgment, but technically the kids fall off the table if they're well able-bodied children. They fall off the table after the child support ages. So I don't know if I'd necessarily say in my situation, I'm a husband, we're getting a divorce, I have 3 kids. I'm typically not going to say, yes, I'm going to cover all insurances in college. I may very well do that voluntarily, but as a divorce attorney, I don't think I'd be telling a client I want that put into a judgment, because it's holding you to something that the courts necessarily are not going to require you to do. But if you want to hold yourself to it, that's fine. Now, maybe the parties agree and say, I'm just getting my business off the ground. I'll cover when the child gets to college ages, but maybe pay less during this time period. So therefore, I am willing to sign myself to a judgment. But typically, post-child support ages, that stuff kind of falls off the table unless the parties truly agree to it. And usually the divorce attorney, the one that's going to agree to that, is going to be strongly saying, I don't want you to sign anything that locks you into anything beyond that age. If you want to do it, but I wouldn't necessarily ask a client to do it if they're the one. If they're the one that's going to receive it, then I'm all for it. Go ahead. If he's or she is going to agree to it. But you don't see it very often. You see it once in a while, but not very often.
So those are unusual.
Yeah, that post graduate from high school, that's pretty unusual to see that.
All right.
Okay.
Well, thank you so much for your questions. Go ahead and keep asking them. We're happy to ask Joe these questions.
Yep, definitely. So re-entering the workforce, and this is one that we had talked about, Marcia. So that's a tough situation, and it could be a man or a woman. I mean, yeah, I would say typically, I think it's changing. I would say the 40 and unders are significantly changing in this regard, because 40 and under men and women are making the same amount. Although if you have children and you decide on that I'm going to be the one staying home, or you're the 50 and up and you've been home for quite a while, it's a new situation. I think though, just in general, it's good to get out there, be active. You hope you're in a financial situation where, if I was really more of the at-home person, that I'm going to get enough assets, or I'm going to get enough spousal support that kind of either takes me the whole way or takes me a good part of the way, that allows me to get kind of back in action and back out there into the workforce. And we've had it quite a few times where the parties agree and say, in a situation, mom says, okay, I had my degrees, I practiced law, I was an engineer, I was whatever I was for several years, but we started having children. We decided I'm going to stay home with the kids. And now I've been out of the workforce for 20 some years. You see this happen. This is 40s and 50s, I would say, are the number one divorce ages that we see people getting divorced at. So you might have a mom that stayed home, had her degrees, but she's been out of the business loop for 15, 20 years. It's really hard. So we're hoping, like I said, there's enough assets that will allow you to maybe go back and re-educate, get back on top of it. Sometimes you want to go in a new path in life, but it's a challenge. It's a gigantic new chapter in your life, and we try to tell people to stay positive with it. It's like I said, it can be difficult, obviously, because a lot of times what happens in a case, when I would talk to people, and like I said, we usually had 90% of the time had the woman in the divorce, and 80% of the time she was not the breadwinner, because she stayed home for a big chunk of the time with the kids. And the divorces, like I said, most filings seem to be between age 40 and say 60. So she's getting back into it. So it's a big challenge for her to get back out there and reacclimate herself to the working world. But it becomes part of your life, and you have to do it, and you're going to have to get out there, and you're going to have to start fresh, and you might start at the bottom rung of some type of business situation and rise up. But people have done it, and people have been very successful at it. Like, it's another one of those ones where every situation is different. If you have a situation where you have $1 million in assets, and you can say, okay, I can sit back and I can survive on these assets the rest of my life, that's fine. Or I can survive on these assets, go back, finish my degree, or get my master's, get back in the workforce. One good thing is, I think so many more employers are becoming understanding, receptive, and that may very well be because more women are getting in the workforce. So they're saying, no, we're going to take care of our fellow woman. I think when you had all males in the workforce and running the companies, I think they were probably honestly less receptive to kindness and understanding. But now with social media, with everything out there, companies are becoming a little more understanding. And I think, I think you can probably Google search companies that are more welcoming to women getting back out there after a difficult divorce situation, and there'll be receptive companies that will let you get in on the ground floor and get going. It's going to be a challenge, but like I say, stay positive. You can do it. But yeah,
Thank you. And I wanted to say there was just a comment here about that's true about having to start from the beginning again. But this particular person said, I had to start at the ground level, but now I'm at a good place, and I still have several years of child support left.
good. Yeah.
So I'll be self-sufficient by the time the child support is done.
Yes. Yeah. Every situation, it's hard. It's a hard point. It's very it can be very challenging if it's because you may have started having babies in your mid-20s and you just dropped your career at that point and find out, I like to be candid and honest about this stuff. You find out at age 50 your spouse is having an affair and you get a divorce at 50, and I haven't been out there for 25 years. It's tough. You want a good attorney, and sometimes you might be in that situation and your husband's making 35,000 a year and you guys have debt greater than your income. It's tough, but people will manage and they'll survive. But it's a new chapter, and that's why that's a nice picture with it. It's a good, stay positive.
Thank
It'll
you.
work out.
Let's talk-
Retirement. Okay. Yeah. So this is where, like I said, and because this is our niche market, working with women, divorced, widowed, or single women, and going through a divorce situation or a widowed situation, a couple big factors come into play here. So it's nice if we can be involved during the divorce process and we get somebody who contacts us. I'd say probably 25% of the time we get the opportunity where it's much nicer if we can be involved in the process while the divorce proceedings are going on. So we can be coaching our future client, helping them through the process, working with the divorce attorney. But 75% of the time, somebody comes to us right when the divorce is completing or after it's completed. So we didn't have as much offerings or ability to help out in the process. But when you're getting a divorce, like I said, we really think you should be working with somebody where it's a niche market and it's something that they truly specialize in, because it is a specialty. Just like there's doctor specialties, you don't go to your general practitioner to give you a heart bypass. There's specialties in retirement planning. There's people that specialize representing typically males in situations. Female is definitely more of a niche market. There's people that specialize in older people, that people specialize in the younger years and accumulation years. So you want to look for a specialist. But what happens at a divorce time, and especially, like I said, our client is 50, 55 and up. These are just facts that I can openly hand out. I don't agree with it necessarily, but I'd say 90% plus of the time in the 50 and up market, being a widowed or divorced, the husband was the one with the relationship for the financial advisor. A lot of times the wife might have been the one doing the budget and paying the home bills, but the relationship with the financial advisor was with the husband. So when it comes down to it, we just think about this in your mind. So my husband, I've been married 30 years. My husband has had this 20-year relationship with our financial advisor. I've seen him 3 times in my life. We highly recommend that you seek out your own financial advisor after your divorce. One thing, that's personal. Your money's very personal. The last thing you want is your husband going and saying, well, how's Carol's investments doing? Or how's, and if you've had and there might be confidentiality, there might be those type of situations. But the last thing I want is being divorced with somebody for 2 years, whether it ended nicely or it wasn't very pleasant, is my husband knowing where my assets are, what I'm doing, how they're growing. So we really recommend that you seek out a specialist and that you seek out your own financial advisor, either during the divorce proceedings or in a widowed situations after the passing of your husband or after your divorce. But yeah, I can't say that enough. That's really important. Now, what you're gonna do at that point, then so remember, you were two entities that were, or really two people, one entity during your divorce or in a marriage situation. After your divorce, you now become two separate entities. So whatever retirement plan you guys had in place, you and your husband, or whatever you were working on, remember that has changed now. So you need to work with an advisor that's a true retirement planner. And like I said, a specialist, but somebody that can really build you out a plan, because now we're going forward and we're building out a plan. We have to take, okay, you got $300,000 in the divorce. You got a portion of the marital home. You're getting spousal support. Right now, your income's low. We got to build out a budget for you. We build out a retirement plan. We want you to enjoy life. We have to determine when will I start spousal or start Social Security now. These are the kind of things, like we're a Social Security specialist also. So we can coach people on what's the best time. Should I draw? Should I draw off of my husband's Social Security? A lot of these factors come into play when we build out that retirement plan for people. So it's important to really start fresh, build out your retirement plan, set your goals. Investments may be different at that point also. If we're fully licensed, we always recommend that you work with somebody that's a fiduciary, which is what we are, and fully licensed. Fully licensed mean you're licensed in insurance and annuity, long-term care products, as well as licensed in brokerage products. Brokerage products would be what you consider comparable to like your 401ks or your Merrill Lynch, Morgan Stanley accounts, those type of things. So those are considered brokerage accounts. Now, annuities and insurance are on the insurance side. We got to look at what type of investments you were awarded in the divorce and figure out what's the best situation. Do we want to put some money into an annuity that has a guaranteed income rider? Say my husband, he's got the income source. He's going to be making money. I am just getting back in the workforce. He's going to be making 200,000 a year. I'm going to start out at 25,000 a year, but I'm getting a nice chunk of money. Maybe we want to take that money, put it in an annuity that's also going to pay you a lifetime income stream. Maybe we're going to look at all the variables. Now, the way it works in a divorce situation is, like I said, from the date going forward, everything's marital. So I quit work. Say I was a wife. I quit work when I was 23 years old. I don't have a 401k. 40 years, my husband's been allowed to build up that 401k, and now it's 1.2 million. Technically, right off the bat, you are entitled to 50% of that 401k. You're entitled to 50% payout of whatever that pension is. You're entitled to 50% of whatever assets you accumulated, including marital home. So you're entitled to 50% of all those. Now, the way that the courts do it, they do what they call a quadro or a QDRO. You file your judgment, and then judgment of divorce, and then a quadro QDRO is filed after what that's called a qualified domestic relations order. So that is how you divide up those marital retirement plans. So what happens is your husband had his 1.2 million 401k, and I'm just throwing out numbers that it might be 120,000.
Yeah, this is just a.
These are just numbers, and sometimes I'm going in my head of cases that we worked on lately, but a $1.2 million 401k, we're kicking it off. I'm getting 600,000. Remember, that's still negotiable too. You got a situation where her husband's messing around, and we're going to say, okay, we're going to drag this thing out for a year and a half. So you end up paying me 700,000 or 800,000 because you messed this thing up. That's the reality of a divorce case and good divorce attorneys. But say in this case, we're getting our 600,000. There's no penalties. It's almost like your money was held at the 401k at your husband's work, or the money was held. The QDRO, Qualified Domestic Relations Order, spawns off a mini $600,000 401k with you. He retains his own 401k. Typically at that point, that's when people will then take that money and move it to an independent advisor to become their representative for their retirement planning. Like I said, I don't recommend leaving it with your husband's financial advisor. I don't recommend it leaving it at your husband's 401k group. Yeah, you want your independence. You want to start fresh. You want to do your own thing. In addition to that, independent advisors have much more opportunities and different types of investments available that 401k plans don't have. But that's how the division works. Like, so don't think, okay, it's going to be a $600,000. It's going to kick out to me. No, I'm going to have to pay taxes on this. Nothing happens as far as what it becomes. In the IRS's eyes, it's still a 401k. It's just, you've just kicked off your own little mini 401k. But it's as if you are retired, so you can move that money. Just a general rule, so people understand what I'm talking about there, is there's two ways. If I'm working at, I'm we're in Michigan here, so I'm working at General Motors. I'm 50 years old and I have 500,000 in my 401k, and I'm still active at General Motors. I can't move that money to a private investment advisor. Most of the private corporations in Michigan at 59 and a half, you can still be employed at that company, and you can move your money to a private investment advisor if you'd like at the 59 and a half point. Some places like University of Michigan and some public places, you have to actually be retired before you can move that retirement plan money. But in a divorce case, now you've spun that off, or take it one step further. I was at General Motors for 25 years. I have 500,000 401k. Now I moved to Ford. I can move that $500,000 to a private advisor at that point. That's what a divorce situation is almost like. They've spawned you off your own $600,000 in that example. You have the ability to move it wherever you want without penalties, without taxes, and it just becomes an IRA. A 401k equals IRA.
Thank you. I know we
Okay.
don't have a lot of time left to do questions and answers, but I do want to go ahead and get to a few.
Okay.
So can you talk a little bit about what happens if your spouse fails to pay child support or spousal support?
Okay, so what happens with failure to pay child support, spousal support? So this is one of the things I said. I would say 30-40% of the time after the divorce judgment is over. Unfortunately, you think, okay, I'm divorced, it's good, we're going our own direction. People violate the terms of a judgment of divorce, and you end up having to bring them back to court. Child support, you may very well, and this happens a lot with child support and a lot of times custody stuff, where a lot of it's what they call post-judgment, where you're having to go back to court. You might have to force the court to, well, typically child support, if your husband is working at, say, General Motors, Ford, they're working at a set company, a child support order is in place with that company. So the money is being directly withdrawn from the company. Say the husband quits and moves to a new place, and now he's refusing to tell the friend of the court. You're supposed to tell the friend of the court who your new job is, give them all the information so they can take that order and attach it to the new company, so it spits out the money automatically. The problem
So it's just an automatic payroll deduction, and
and nowadays everything with technology, it's just it's going to spit over. And if that person works at the same place forever, it's just nice and clean and cool.
is that something that the court is involved in, or?
Yeah, what will happen is, friend of the court, you'll end up putting it will be in the judgment of divorce. We'll have the child support or spousal support order as well. There will be the child support portion will also have its own friend of the court order, and friend of the court. Then once it's all locked in, we'll go ahead. That will get submitted over to, say, General Motors, and General Motors payroll department will get the information and see, okay, we're kicking out this check to wife automatically. The problem comes in is when that person either moves to a new job, they're supposed to notify friend of the court. Sometimes people don't. Sometimes people play games. Sometimes people leave the state. You got to bring them back to court. You got to file a post-judgment motion to get them back to court or back to the friend of the court. Argue with it. It's a big problem in cases. The big problem in cases, though, really is when you have somebody who is self-employed, because and difficult ones, honestly, were like restaurant owners, builders, people that might be getting cash. It's hard to stay on top of the situations. You might find you got 15 years of bringing this person back to court because they keep saying they're broke, but they're living in a $500,000 home. Well, courts, the friend of the court and courts will impute an income to somebody is what they'll do in those situations. And I get a specific situation right now where the person is almost refusing to work, even though they have the ability to make a ton of money, who's supposed to be paying some of the support stuff. So it's going to be she's going to end up bringing that guy back to court potentially several times to keep doing it. When you bring them back to court, you might say, your attorney might say, I want $1,500 in attorney fees. It's really an ugly part of divorces is the post-judgment stuff, because you might have to do it. And the problem is you got to re-retain that attorney afterwards, even though you did nothing wrong. And courts won't always award attorney fees in those situations, but your attorney will go in there and say, they clearly violated the spousal support portion of a judgment or the child support portion. You file a post-judgment motion, serve it on them again, just like you're starting the case all over. Go in and argue it with the judge. Judge is most likely going to be on your side if you're right about it, and hopefully they'll award attorney fees. But it's an unpleasant part. Post-judgment stuff is very unpleasant with child support and spousal support, because if it's tied to a company, fine. If it's not tied to a company, then, and you're relying upon that person to write that check every month, I would say in these situations, I definitely want to say this, especially to the ladies, because guys seem to be the culprits of this. Don't be too nice in a divorce case. Don't be nice and say, no, he said he's going to pay me the first of the month. He'd rather not go through his work. He's embarrassed. Who cares? Get it through the work, because a year from now, 2 years from now, you start dating somebody else, all of a sudden he cuts off those payments. I've seen this kind of stuff too much. So if you have the opportunity to have the direct deposits or draws coming from your husband's work, always do it, even if you think you have a very kind relationship and everything worked out fine, because things change when you start dating, or something happens down the road, or he starts dating and his ex says, stop paying it, I want the money. Stuff happens. So always try to lock it into a direct if you can. If you don't, and he's self-employed, then hopefully he's a good person. Otherwise, you may end up having to do some post-judgment motions to force the court to kind of punish him.
Thank you.
Yeah.
Thank you for that information.
You're welcome.
I do have a pretty specific question here, and I'm probably going to direct that person to contact us directly, so we can
Okay.
refer them to someone. But I do want to ask, is it possible for a wife to get some of a spouse's Social Security if they still need that support?
For Social Security?
Yeah, Social Security, because typically, like, the higher income earner is going to get more Social Security.
Yeah, just a quick little, Social Security is its own gigantic thing. We do Social Security seminars, but Social Security in general, to have been married for 10 years to collect off an ex, be 62, just like you do a regular Social Security before you can start drawing, and you cannot be remarried. So if you remarry, you're losing the access to get the Social Security off of an ex. Now, I don't want to get too deep into it, but they call it something called full retirement age, and Social Security is usually around age 66, 67. If you see your Social Security statements, typically what somebody's entitled to husband's full retirement age on Social Security is considered 66. And at that age, he would be getting $3,000. I am now 66. We're divorced. I'm 66. We were married 10 years. I fit all the categories. I didn't remarry. I'm entitled at full retirement age, which say that's 66 also, to 50% of his Social Security. If I want to start drawing it at 62, I can, but I'm going to get a reduced amount of that 50% of his.
Okay.
So it's very complex. But
and we do have webinars about Social Security, so I do want to refer people to look at those resources that we have.
Yeah.
But I think what they were asking is, can you get a judgment to get some of the can you go back to court and get a judgment to get some of the Social Security income from the spouse that is getting a larger amount?
Well, I don't think in a judgment they're going to call it. See that you're bringing in Social Security Administration, so the Social Security Administration, I don't think cares what your judgment says. It's like its own entity, just like a mortgage company. So I think you would have to work it into the terms of the judgment and almost make it, that'd be something you'd negotiate and say, okay, he's getting 4,000, I'm getting 1,000. It's our only main source of income coming in. We never did it. I don't think, because you're bringing in a third entity, the Social Security Administration, I don't think you can, you're necessarily saying a judgment. I mean, it's possible, but I can't remember that ever coming up. But you might make it a spousal support item and
All right.
say he's got to pay me that extra 1,000 to make it equivalent.
So I'm going to go ahead and
That, I don't know,
this is a very specific question. And that's why we
Yeah.
don't give specific answers, because it's so different for everyone.
yeah, that's a
tough one.
I can't, yeah, because I don't know, I don't know how you would go to Social Security Administration. I don't know if they'd look at a judgment, because they'd have to look at a judgment then and say, okay, and their systems, they got like set gigantic computer systems that are spitting these things out. I don't know if you can disrupt their system, or if that person would just have to say, okay, for the rest of my life, we're going to negotiate that I get $1,000 or spousal support to equal
And
the
the
difference.
spouse writes a check, the ex-spouse writes a check.
Yeah, like, yeah, to kind of equalize it that route. It might be possible, but we did 300 plus divorces. We never did that. It's possible, it's out there, but I'm thinking Social Security Administration.
As far as doing an auto withdrawal, you don't think that?
Yeah, I don't know if they
that's-
would be able to do that based on that, because they're really just looking at what you've pumped into the system
Mhm.
and the variables of who can get what.
What happens on, I'm sorry, can you, and this is one last question. I know we are a little bit over time, but I want to get this last question in. Can you specify in a divorce decree that the spouse retain in like life insurance with you as the beneficiaries, especially if you have young children?
Normally, after, well, we normally tell people change your beneficiaries at the end of when the judgment is filed, get your spouse off. That's pretty much number one. Last thing I need is my spouse coming in, killing me and collecting the money. I mean, it sounds harsh, but that's the reality of it is.
Okay.
Got a greater chance of a ex-spouse killing you, you know. So typically, you might say, and once again, this is an outside contract outside of the judgment. So you'd hope the ex would be good about it, but put kids on there. But I've had a couple situations where the person's like, no, I'm going to keep my ex on as the beneficiary of my life insurance. I'm like, oh, okay. I wouldn't recommend that, but if you want to, you can. But typically people change that beneficiary as soon as that divorce is complete. They change it, or even during, well, say when the divorce is complete, they change it. But you can request that maybe they put the kids on if there's kids situation.
Okay, so instead of having the
Yes, yeah,
beneficiary
maybe
be
the
the
primary.
ex-spouse.
Yeah, like primary, my ex-spouse. So I'm married. I had my wife on as my 100% primary beneficiary. Divorce is over. I'm going to switch over and say I got 2 kids. I'm going to switch over and make my 2 kids 50-50 primary beneficiaries and get her off of it. Yeah, we've had it before, but like I said, if somebody wants to keep you on as a beneficiary, do it. If somebody's trying to tell you that they want to stay on as your beneficiary, your ex, forget it, unless you're really extra kind.
And then, of course, the beneficiary, I know that we've talked about this in other webinars, that could be a trust for the children or whatever.
You could do like a trust. You can do different things like that. And the kids part is good. Go ahead. Yeah, you want him to do that, and that can be something where friends of the court may, will force the issue to say you have to maintain a certain amount of insurance with the kids as beneficiaries, because that's making up for the child support in case something happened. Your kids are 5 and 6 years old. You got 13 more years at $3,000 a month child support, and you die. So you're going to want the kid, the ex in that situation who's paying the child support. You're going to want them to have a big enough policy in place for the kids as beneficiaries, but more likely than not, he's gonna take you off of the policy as beneficiary. But you definitely want it for the kids to cover potential what happens if, because that could blow up a whole situation if you got a husband that had a big income, paying big child support, didn't get health, life insurance and passed away. Of course, though, you got situations where somebody might not be healthy and might not be able to get it. But you definitely want to, if they're capable of getting it, to get life insurance significant to cover future child support payments in case something does happen.
Well, thank you. I know that we could talk for probably a couple more hours, but our time is up.
Okay,
Thank you so much for being with us today, Joe. We want to thank the organizations that have made this webinar possible. And of course, if there are some more questions, go ahead and leave your phone number in the chat so that if we haven't had a chance to get to the questions, we can reach out to you.
Yep.
On behalf of Advice Chaser, I want to say thank you everyone for attending. We're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners is committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. So once again, from Advice Chaser, thank you everyone, and we will see you at another webinar soon. Bye everyone.
Bye, everybody. Thank you.